This will be our review for your semester of evidence. And so I'm going to start to share this screen. And all right. So welcome to our review for evidence. And I want to let you know about, what we've talked about this semester and kind of how to think about preparing for the exam. So just as an introduction to the whole class, you now had it. But if we were to go back to the very beginning and ask that kind of fundamental question of what exactly is this class about, it would be about this picture that you now see, courtrooms. When can you get information that you would like to have the fact finder hear to his or her ears and eyes, or smell, or whatever other senses will be involved? Evidence is not a class about the sufficiency of a claim. It's not about whether you have proven anything or not. Evidence is solely a class about when you can have what you want to have heard. So fundamentally, the question is, what gets presented at a trial or at a hearing? We started with the idea of relevance. And relevance seems fairly obvious. Does this thing have anything to do with the trial? And that's expressed in this, kind of fancily written rule that if a fact that is of consequence in this litigation is in any way more or less probable because of what you want the fact finder to hear, then that piece of evidence is relevant. Now, I talked a lot in class about how I didn't think there ever really was a true relevance objection. Unless one of the lawyers is just completely going off the rails, and that will sometimes happen, but that's certainly not going to be the norm. The lawyer will have some connection he or she is trying to make with the thing that's being offered and the conclusion that is of consequence. So the real objection that I think you get when people jump up and say, "Objection, Your Honor, relevance," what they really are saying is that the connection that the lawyer is trying to make with this piece of evidence is too loose or comes with too much baggage. That the inference that the lawyer wants you to make from this evidence, even if it's there, it's going to be tenuous. We looked at the Hit case with the picture of the gun that was supposedly clean on the inside, and the picture was the outside of the gun, and it was surrounded with that array of other guns and knives. And the court there said, look, maybe this shows a little bit whether the gun is clean on the inside, and I think it does. If something's clean on the outside, does that marginally raise the possibility that it's clean on the inside? Sure, maybe, but not very much. And when you add to that the fact there were a bunch of other guns in that picture, that became a problem. So when we speak of relevance, it will be a shorthand term on TVs and movies, and certainly in real life. You'll see, people jump up and say, "Objection, Your Honor, relevance." I think what they really are saying is this Rule 403, that even if it has some tendency to make a fact of consequence more or less likely, there's a risk of unfair prejudice. You're injecting things into this case that have nothing to do with it and will cause the jury to make a decision on the wrong basis, confusing the issues, misleading the jury, wasting our time. That this might move the needle ever so slightly, but it's going to take us 30 or 40 minutes or an hour or a day to get it in. Or we've already covered this ground, and this is just another marginal point that's being added. This is the 250th witness who claims to have seen something. So then we looked at character evidence. And I've got the little good and bad angels on the shoulder of Homer Simpson. And when is it that we get to say, whether a person is motivated by good or bad angels? To put a real cartoonish spin on this, when do we get to say that there are patterns or traits that someone has that we then get to present in evidence? So this is governed by Rule 404 and 403, and I could have added there 413 to 415, which are the sex crimes rules, and I'll come back to those in a bit, but I'll also add them into this discussion. So 404B is the one that you've heard the most about, but it's preceded, of course, by 404A. 404A says that when we're looking at character evidence itself, that has to be presented by way of testimony about someone's opinion or reputation or someone's opinion about the person, or testimony about a person's reputation for having a particular character trait. When those things are at issue in a trial, then you can present evidence primarily only by way of character evidence through opinion and reputation testimony, with just a couple of exceptions. In a libel case, if the character trait itself is on trial, in a libel case, your character for whatever you've been libeled for is very much on trial, as is the general value of your character. In those kinds of cases, you can present specific evidence of a person's good or bad character trait. If you're suing me because I said that you were a bad lawyer, then every instance of your lawyering now is fair play. In one of the Massachusetts cases we looked at, the court said in that jurisdiction you could also look at specific acts of aggression. If you have a homicide case, that who was the first aggressor, if the claim is self-defense, or an assault case, the question of who was the first aggressor is at issue, and therefore you get to bring in specific acts. Most jurisdictions regard that differently. Most jurisdictions say in a homicide or assault case, even if you're claiming defense, self-defense, that who the first aggressor was is not the primary issue in the case, and therefore the victim's character for aggression is something that can only come in through testimony about the victim's trait, or known in the community, or someone's opinion of the victim's character for aggression. So 404A, when a character trait is part of the trial, and that's pretty much only in libel or in Massachusetts for aggression, then when character is permitted, and it rarely is, it will be a side issue, and you only bring in reputation or opinion testimony to prove that particular character trait. You don't bring in specific acts. 404B then talks about specific acts, and basically what 404A giveth, 404B taketh away. If you look at this rule, it's extraordinarily broad, and then you look at its application, it's even broader. So you cannot, we learn in 404A1, bring in character evidence to show conformity therewith. 404B1 says you can't bring in other bad acts to show that the person acted consistently with those bad acts or those other acts. But 404B2 then absolutely removes everything in 404B1. So I guess I should say what 404B1 giveth, 404B2 taketh away. And the exceptions in 404B2 are just so extraordinarily broad. If you are offering this to show motive or intent or absence of mistake, to show this thing actually did happen as you say it did as the prosecutor or the plaintiff, and not by matter of coincidence as the defendant claims, then you can bring this in. This is modus operandi. If you want to bring in other acts to show that the defendant had knowledge of something, to show that he knew what drugs looked like, then that comes in. So there's a broad range of things you can bring prior acts in to show in the current case. 404B1 says you can't bring it in to show propensity. And the rule doesn't state this. And a lot of evidence professors disagree with the way I characterize this, but I think it is inescapable that what 404B2 says is, but you can bring it in to show a person's propensity to have a particular motive, a particular intent, a particular modus operandi. So oddly enough, you cannot bring in prior acts of stealing to show a propensity to steal. You can bring in prior acts of stealing to show a propensity to have the intent to steal. If you find it hard to square that circle, I am with you. 406 then talks about habit evidence. And habit and character are just two sides of the same coin, or just in different places on a continuum. Character evidence, you can't bring in the past to show the future, although there are plenty of exceptions under 404B2. But let's take 404B1 and 404A1 to say you can't bring in the past to show the future, unless the past happens with a sufficient amount of regularity and in a sufficient number of cases in response to a particular stimuli. If this happens frequently enough that it's almost automatic, then you get to bring in the past to show the future. The defendant in the one case we looked at who said he smoked pot every morning. The stimuli was the sunrise, and the response was smoking marijuana. The court says, yeah, that's enough to show habit. Policy reasons for excluding evidence. In the relevant stuff, we say, does this make a fact at issue somewhat more or less likely? We now look at policy limits and say, even if it does, there may be times where we still don't allow the evidence in. Subsequent remedial measures would be one of those times. We want to leave the incentive for a company to clean up after itself. We don't want that cleanup we don't want to discourage that fixing or that cleanup, knowing that it'll be used against them in litigation. We want parties to settle cases, so we don't bring in evidence that they talked about it. And in the course of the discussion, one of them might have made a statement that was problematic for his or her case, because then people won't talk. They'll be afraid to talk and they might not actually settle things. Payment of medical expenses, we don't want to discourage charity. References to insurance coverage. It might be relevant that you're insured, but we also are afraid that juries will overcompensate people who are insured. And so we exclude that testimony unless the notion of, or the fact that someone was insured would somehow show a bias that the witness had. Rape shield laws, we don't allow certain evidence to come in about a victim's past in a rape case. Would have marginal relevance, perhaps, but we don't want to discourage victims from testifying in rape cases. And then prior sexual misconduct. We touched on that in character, and it may better fit in that category of character than it does in policy. But Federal Rule of Evidence 413 through 415 says that anytime a person has engaged in sexual misconduct, that can be offered for whatever the purpose that it might have, any propensity or any other purpose that it might have in the current case. So if you're charged with rape on day 5 and you had been convicted of rape on day 1, that's coming in. and it doesn't matter how similar those two cases are. State rules allow a similar type of thing under modus operandi, under 404B, but they require a closer connection, and the scope of the prior cases that would come in are going to be more limited in state courts that have not adopted 413 through 415, and that's the majority of cases. That's the majority of states. So the federal government or the federal courts are much more permissive of prior sexual misconduct as character evidence in the current case. Hearsay. This is the really big thing. The bulk of evidence law is hearsay. There will be other issues on your exam, but make sure you know hearsay, because I guarantee you there will be hearsay issues on your exam. The definition, I restated this in class a number of times because I want you to have it down. It is an out-of-court declaration offered for the truth of the matter asserted. That last phrase, truth of the matter asserted, is fundamental to this and a very easy way to get evidence in. If you can say, Your Honor, we're not offering this for the truth of the matter asserted, you better be able to finish that sentence. But once you can, you're golden. We're offering this to show the effect on the hearer. We're offering this to show that the defendant or the plaintiff had knowledge. And then we get in the rest of Rule 801, non-hearsay. And I mentioned a lot of times in class that these items identified as non-hearsay really do not differ at all from hearsay exceptions. But they're identified as non-hearsay. So, if you can remember that, it'll get you a few bonus points with a judge. If you can't remember what's non-hearsay and what's an exception, it'll never harm you. But the non-hearsay provisions under 801D come in two types: prior statements of the witness and party admissions. Prior statements of the witness clearly require the witness to have testified. And we know that if it's an inconsistent statement and if the prior statement was made under oath, that comes in as substantive evidence. Don't confuse that with impeachment, with a prior statement that is not under oath that can come in to impeach, to muck up the story of the witness, but cannot be offered as substantive evidence. Prior consistent statements can be used to respond to cross-examination. Depending on the nature of the cross-examination, it will vary in whether you're allowed to use it. Basically, if the prior consistent statement actually serves to rehabilitate the witness, you're allowed to bring it in. Prior identification. You identified your attacker in a lineup. You can bring in that testimony. Party admissions. These are really easy, and the party presumptively is in court, either actually sitting there or is bringing the case. So in some ways, both 801 D1 and D2 are similar. They involve people who are involved in this litigation in some way. Anything you say to anyone as an individual, as a party in litigation, that's coming in. Any statement you adopt, someone says something and it's incriminating against you, you don't correct it, or worse, you agree, that's coming in against you. Your agent or employee in the scope of the employee or agent relationship, or a co-conspirator statement that's offered in furtherance of this conspiracy. And that's a very, very broad concept. Many things further the conspiracy, even if it's just bringing others up to speed, even if it's feeling out people for the possibility that they would be willing to do something. You can pretty much craft a theory for how a co-conspirator statement advances the conspiracy pretty easily. And courts are very ready to accept theories that show that these statements advanced the co-conspirator relationship or goals of the conspiracy. The one thing you have to remember there is a court has to first find that there is a conspiracy before they let the statements in. And while the statements themselves can be used to show the conspiracy, you always have to have something more to corroborate it than just the statements themselves, but the statements are part of the proof that there is a conspiracy. Then there are the exceptions under 803 and 804. 803, the witness does not have to be unavailable. The witness can be there, cannot be there, can be alive, can be dead. It doesn't matter. And we looked at those examples: present sense impression, something that's blurted out at the moment; excited utterance, you're still laboring under the anxiety of the situation; then existing mental, physical, emotional condition. I'm sad, I'm happy. But more importantly, that's the Hillman doctrine. I plan to go to Crooked Creek with Walters. I plan to meet Walters there to show that Walters was actually there with you. Again, it's not conclusive, but you can offer it for that purpose. And the Hillman doctrine makes 803.3 a very, very important rule. Statements for medical treatment and diagnosis. So like if you are going to a chiropractor in litigation to show you've got a bad back, not to fix it, but to get money, even those statements come in. Business and public records, very important rule. If you are regularly in the business of doing certain things and recording those things can come in, those documents can come in. You know, you have a store, you make the receipt whenever there's a sale, you file it every single time, and the person who filed it had knowledge of what is in that record. The absence of those records, if you made a sale, it would be in that drawer. It's not in that drawer. Therefore, there was no sale. Public documents are the same. You simply have, instead of a company, you have, you know, the agency, the Department of State, the Deeds and Records Commission, whatever the public administrative thing is, they're keeping records of the business that they, as a government actor, do. Family records, you know, if you're looking at family records, trying to get those in, there are about 18 different ways under the rules of evidence. Pick one you like. You'll find one. There are 5 or 6 under 803, and then just for good measure, there's one under 804. Don't ask me why. If you can figure out a way to show it's a family record, you know, list 4 or 5. I'm kidding. Find one you like. Find one that works, and you're good. Ancient documents is a weird rule that you can bring in an ancient document for what it says. Now what's really interesting about this is that if there's hearsay in the ancient document, if it relies on something else. So like if I write out in my diary something and 20 years later they want to bring that in, that's admissible because the document's more than 80 years old, more than 20 years old if it is. So something I wrote in my 20s. But if in my 20s I say, my friend Bob said this, then you've got hearsay within hearsay. And courts will split on what you do with that hearsay within hearsay in these ancient documents. And that is sort of unusual, but that's the concern about hearsay within hearsay for ancient documents is kind of an unusual quirk of this. Market reports, you know, anything that reflects business transactions or dealings, things people rely upon. Market reports could also be weather reports, things that are regularly recorded that people rely upon. Learned treatises, Gray's Anatomy is an example of this, describing the anatomy of the body. You can't just pop the book in front of the jury. You've got to have a witness who describes it for the jury, because we wouldn't want the jury, you know, going off on its own, flipping through this and misinterpreting things that are usually pretty technical. 804 exceptions, the defendant actually, or the witness actually has to be unavailable, dead, sick, away. And by away, we mean beyond the ability of the court to subpoena this person, have a privilege against testifying, or refuse to testify. Former testimony comes in under this rule if the party who is bringing the testimony either cross-examined that person previously, or someone else did who shared the interest of the party that's now that the testimony is now being used against. Imminent death, often referred to as the dying declaration. The federal rule is a little wonky in that it doesn't actually seem to have to require the person to die, although it would be an unusual circumstance when that applied and the person hadn't died. Family history, again, 18 different ways to get that in. Forfeiture by wrongdoing, really important one. You cause someone not to be able to testify. You kill them, you threaten them, you send them away, and if that's the reason that they're not able to testify, then anything that human being has ever said about you that would hurt you in this case comes in. Forget the hearsay rules. Impeachment. So impeachment is easy to conflate with prior inconsistent statements. And hearsay, you have to remember that what we're doing with impeachment is essentially saying to the witness, you're not telling us the truth. Whether that's because you're not doing so on purpose or that you're mistaken, the whole point of impeachment is to show that you, as the witness, are not telling us an accurate story. So one way to do that is to show that the witness is not truthful. You can show that by calling witnesses who believe this person is not truthful through that person's reputation or that person's own experience. You cannot, however, bring in evidence that the person lied on their taxes. You can ask the witness, did you lie on your taxes? If the witness says no, you're stuck. Criminal conviction. Witness on the stand who's been convicted of a crime, you can bring in evidence to show that fact. But not always. The balancing tests that are done under Rule 609 turn on whether the witness is the defendant. If not, it's going to be easier to bring it in. What was the penalty for the crime? If it was a felony, it's going to probably come in depending on how old it is. Did the crime involve dishonesty? If it did, it's probably coming in regardless of whether it's a felony or misdemeanor. How old is the conviction? Now, if it's beyond 10 years old, no matter what the categories are, it's going to be harder to come in. Open that rule up if this comes up on the exam or in real life, and look at the balancing test. There's no way you'll remember them all unless you pull the rules out. Inconsistent statements by witnesses or others. If the witness has said something contrary to what other people have said, to what other facts can show, or what the witness himself had previously said, you can bring in extrinsic evidence of that inconsistency if it's at the heart of the matter of the case, not some tangential issue. And you can always ask the witness about inconsistencies. You can say, didn't you say the carpet was actually yellow? Or isn't the carpet actually yellow? But you cannot bring in extrinsic evidence to prove the carpet was yellow if that's just a tangential fact, if that's not related in some way to the case. If you look at the state rule that many state courts have adopted, 616, it lays this area out, I think, very nicely. And then finally, Rule 612 on refreshing recollections. Anytime you have a witness on the stand, you can ask that witness, does this refresh your recollection? This rule is not to be confused with 803.5, recorded recollection. With that, you have to have only the statement that this witness has written, recorded, etc., and that statement can actually come in. You can refresh a recollection with anything, but that's not going to go to the jury. If this witness previously wrote something down or made an audio tape, you can use that. If the witness still doesn't remember, you can have that read into the record, but you can't have it sent back to the jury. But anything that refreshes a witness's recollection, you are allowed to use. Opinion evidence. Two types, lay opinion and expert opinion. Lay opinion is often described as shorthand, ways in which we describe things that are not, that you just couldn't put into real words. Her facial expression was sad. Her facial expression was happy. How would you describe that in other terms? You know, her the corners of her mouth were 8 millimeters below the center point of her mouth. Her cheekbones, the skin seemed stretched there, and there were wrinkles about the eye. It's really hard to describe a happy or sad facial expression in ways that aren't opinion. Something was fast or slow. Even if you're giving exact numbers, even if you're saying that car was probably going 80 miles an hour, that's going to be an opinion unless you've got a radar gun. But these are the kinds of things ordinary people know and can do. Expert opinions, however, involve things ordinary people don't know. And you don't have to have a PhD to be an expert in something. If you have engaged in study, or if you have experience other people don't, and have developed a methodology for determining facts that would be, oblivious to or not fully understood by ordinary jurors, then you're an expert. And you can testify not just to the things you actually saw, but people can relate the facts to you. And because of your expertise, you can draw inferences and conclusions for the jury. The judge under the Daubert case, however, will ask whether your expertise is in fact reliable, and whether there's a scientific or good technical basis for the type of inferences you're claiming to be able to draw. Authenticating evidence. This is the 900 series. And there we looked at simply, how do you show that something is what you say it is? How do you know, how does the computer know you're not a robot? It'll ask you and you'll click the little button. Basically, it's very commonsensical when you look at the 900 series. You want to show someone who has knowledge of this information identifies it. I recognize the handwriting. I recognize the voice. That is Bob's car in the picture. Authentication, not terribly difficult, but if it's not what you say it is, as a litigant, it's not relevant. So we have to have some way of saying, this is the thing that it is claimed to be. Chain of custody is a great example of authentication. And then finally, our best evidence rule. This comes up when language itself is at issue. Particularly, it comes up with contracts, a warning label, anything where the language itself is at issue. The defendant wrote a confession and signed it. That's the best evidence of that, not what the officer remembers. So if that piece of evidence existed and was not destroyed through no one's fault, then you've got to show the original. You can't say, tell us what's in the contract. If, however, someone has made a statement against their interest describing what's in the contract, that can come in. That's basically the party admission rule. Best evidence, if text matters, if a video matters, if that's the essence of the question, and you got the original, you have to show that. You can't offer a summary of it if there's something better. With the exception then of summaries of incredibly voluminous materials that can only really reasonably be summarized, and then the opposing party has to have a chance to look at it. But summaries for the sake of offering a different spin or drawing conclusions about things that could have just been presented to the jury, the best evidence rule will forbid that. Well, that's it. And as I say, best of luck on the screen there on the exam. It's been a really good class, and I wish you well, not only on the exam, but in your use of evidence in the practice of law.